Hi everybody, Dr. Stringer back to talk to you this week about plea bargaining. We're on to Module 10 already. It seems like the semester is just flying by. So pretty short lecture this week. I know I say that almost every week, don't I? And then I talk for 45 minutes. But we'll see what happens. So we're talking about plea bargaining this week. For those of you that don't know, this is a big part of our criminal justice system. In fact, actually going to trial is pretty rare. For those of you that don't know, in case I haven't mentioned it already in class. And this is pretty much the process of kind of the defense attorney and the prosecutor negotiating some sort of deal in which the defendant will plead guilty, perhaps to the charge that he was initially charged with, or even a lesser charge in exchange for, pleading guilty. So they might plead guilty, or then again they might plead guilty, like I said, to the same charge that they're charged with, but they would get a more lenient sentence or something like that, or a lesser charge. So maybe somebody charged with a DUI might be able to plead it down to some sort of a reckless driving ticket, or something like that. Or someone charged with murder might be able to plead it down to manslaughter or something in that case. So instead of going to jail for life for murder one, they might get manslaughter with like 10 years or something like that. And as your PowerPoint says, the overwhelming majority of cases are handled this way. Very rarely do they go to trial. It's much more beneficial for at least the attorneys and the judge and everybody for these things to be handled this way, because trials are long and expensive and very time consuming. With that being said, so there's a couple of different theories of the criminal justice process. Goodpaster in '87 came up with two interesting models. One being the truth finding, or the adversarial process, and then the second being kind of this fair decision. Those of you that think about, when things go to trial, you have this adversarial process that goes on where you have witnesses, and one attorney asks them questions and then the other cross-examines them in order to kind of eventually find the truth. But when you engage in this kind of plea bargaining action, you're not really finding the truth. You might be getting at kind of what the second idea is with the fair decision, right? Everyone agrees that this is fair. It's important to note, too, the judge doesn't have to accept the plea deal. And this has happened plenty of times. The prosecution can come up with a plea and say, maybe someone is charged with rape. And so the prosecution and the attorney, or the defense attorney, get together and they say, well, what's good for this? Maybe we'll give them 6 months or something like that. And the judge might think that this is too lenient of a sentence. And so the judge can reject this plea bargain and say, no, I reject this. You can either try to come up with a better bargain, or we're going to trial. And the judge can say, I'm not accepting any bargain that has him or her spending less than 5 years in jail or prison. And so the judge has the power to do that, to reject the bargain and to not accept the plea bargain. And so I think I talked about in the last module as well how the judge will actually make sure that you're aware that you're waiving your right to trial and jury, and to confront your witnesses and all these other things too. And if he's not convinced that you are voluntarily giving up those rights, then he might not accept the plea on those grounds as well. So these are all things to think about. Like I said, a lot of times you will, in exchange for pleading guilty, you'll get a reduced charge or possibly a reduced sentence. Sometimes you can get both of them. But then in the end of the day, if you go to trial, most of the time these are going to be up to the judge. And then you won't be able to make a deal at that point. So, arguments for plea bargaining: obviously the primary benefit is it enables the courts to get rid of large numbers of cases quickly. If everybody went to trial, there would be a huge backlog of cases. where people are constantly going to trial, but in getting rid of things through this process of plea bargaining gets a lot of defendants in and out of the court system pretty quickly. There's also economic benefits. It's cheaper. When you hire lawyers and you have trials, and you guys have probably heard of, especially in capital cases, going to trial, these things get very, very expensive very quickly. And so it's a benefit as well. And so, it also benefits prosecutors. Prosecutors are usually judged by how many convictions they get. They don't want to get acquittals on their record because that makes them look bad. So they're in the best interest to get plea bargains where you plead guilty to something, because then you're found guilty. They've proven guilt. Whether you admit it or they have to prove it or not, it still counts for them. So they really want this. They don't want to have acquittals. And like I said before, the trial is an amount of uncertainty. You don't know what's going to happen. Neither side does. Juries are very unpredictable. Judges, perhaps a little bit more, but in the end of the day, they prefer this pleas. And so there's also something that the literature talks about. I don't recall if your book does or not, but there's something in the sentencing literature that they call what is known as a trial penalty. And so if you decide to not take a plea bargain and then you go to trial and lose, then the judge is likely to give you a even harsher penalty for having put the judge and the court through this whole trial process and not just admitting your guilt and reaching a plea. So that's something to think about as well. Obviously, there's benefits to defense attorneys and public defenders who have really high caseloads and limited resources. Usually, if you hire your own private attorney, they'll just charge you a flat rate. So maybe a felony might be like $5,000 for a decent attorney. Misdemeanor might be $1,000. Well, they get that money whether you go to trial or whether they plea it out or not. And it's a whole lot easier to plead guilty than it is to have a full-blown trial, right? And then with the public defenders, obviously they have a very high caseload, so they want to get things turned over as quickly as possible. And it also benefits the defendant, right? If you do end up with a more lenient sentence than you would have gotten, or less serious charge, or something like that, you spend less time in jail waiting for the trial process before you actually start serving your time, this is beneficial to them as well. In the victims, in a case, maybe a rape case or something like that, one of the last things that a rape victim wants to do is go to court and sit on a stand and be in the same room with the person that raped them, and then have to testify to this whole experience and kind of relive it, so to speak. Victimologists talk about how, this is kind of this idea of re-victimization, when you force them to relive that terrible experience. And so plea bargains make it so that they don't have to do that. So this is very beneficial as well. So there's some arguments against plea bargaining too. I've already kind of talked at the idea about how you might not quite achieve the truth in the matter, but there's some others as well. It effectively allows the prosecutors and the defense attorneys to decide whether you're guilty or not, which is something that the judge or the jury are supposed to do, depending upon whether you have a bench or a jury trial. But it is then giving this power to determine guilt to the prosecutors and the defense attorneys. So another thing that usually happens too is the prosecutor will overcharge people. So if you, I'm trying to think of an example here. Let's say, I don't know, there was some sort of assault that goes on. Maybe the person that you got in a fight with was, Jewish or something like that. Well, the prosecutor might decide to charge you with a hate crime for getting in a fight with a person that was Jewish, even though obviously, that might not have been the case, that you got in a fight with the person because he was Jewish. It might just been that, he was an unpleasant drunk person or something like that. But they might decide to charge you with a hate crime for that, knowing that it's going to be easier to get you to plea guilty and take the plea bargain rather than have this hate crime offense, which you would, get several years in prison, I would imagine, instead of, getting, simple assault. And so they might be willing to plead it down to a simple assault, which is probably what it actually would have been anyway. But they don't want to charge you with the simple assault because then they don't really have much negotiation room there. And then it's like, well, I'll give you a simple assault with 30 days in jail instead of a year, but a year is usually the maximum for a simple assault. So these things happen as well. When you think about not only the severity of charges, but they'll also pile on multiple charges. So if you you robbed a bank or something like that, they'll get you for robbing the bank or a gun charge and, a whole bunch of different things in order to try to get you to plea. And then they'll say, well, if you plead guilty to the robbery, then we'll drop the gun charge and things like that. So they do this to try to put themselves in a better position to negotiate. But it can end up with people getting a lot of charges. So there's that argument as well. Then there's also the argument that, it can sometimes be inefficient. Defense attorneys can try to draw things out, hoping that the prosecutors might offer a better deal later on as the trial gets closer. And it's not necessarily necessary to induce guilty pleas. Sometimes people might just plead guilty in and of themselves just because they don't want a trial or can't afford a trial, something like that. So these are all things to think about as you guys do your readings this week and as you're going through your discussion boards and things like that. And I've already talked about how it undermines this kind of truth-finding mission. So that kind of gets at the integrity of the criminal justice system. Plea bargaining, it might result in convictions and sentences that don't accurately reflect the crime. So like I said, the rapist might end up having a really good lawyer and get off with, 6 months or something like that. But then again, the judge could reject this plea, but that doesn't mean he's going to. He might not. So that would depend on the judge. Another thing that can happen, which I think is one of the biggest problems, is that innocent people might be coerced into pleading guilty to the things that they didn't do. You have someone, maybe that, they've got a little bit of circumstantial evidence against them for a murder, and they're like, well, they could actually win this case, and then you would go to jail for life, or you'd have the death penalty, but if you plead guilty, then maybe you'd only get 10 years or something like that. So people might, be inclined to do so. I don't think I would be one of those people. I certainly would not do it. I don't care how much evidence they would have, but I would imagine some other people might be more inclined to do so. Then again, I don't really have to worry about being charged with murders and things like that. Not that I'm immune, I just don't really shoot people. Another issue when it comes to plea bargaining as well, we find that we have, all of these racial issues, biases within most of the criminal justice system. There has been some research out there. The research that does exist kind of says that prosecutors' plea bargaining decisions are determined largely by the strength of the evidence, the prior criminal record, and the seriousness of the offense, right? Those are kind of the big three. There's also some evidence that says that race and ethnicity has some effect on things. And so a number of studies say that white defendants are offered plea bargains more frequently and get better deals than racial minorities too. And also in the federal system, whites receive better deals than minorities do. And then, the Sentencing Commission says that, when it comes to what is known as a substantial assistance departure, blacks are less likely than whites to get this. And what this is in the federal system is they have the actual sentencing guidelines where you're actually bound by, and so they're supposed to go by them, but they have these things called departures where they're allowed to depart from it. And so they used to be bound by them. Now they're not in the post-Booker era. Now they can divert from them as much as they want. And with these different types of departures. And so it's very unlikely for African American and Hispanic defendants get these, it's more likely to go to white offenders. So these are things to think about too when it comes to sentencing. Even though you have these sentencing guidelines you're supposed to go to decide what the sentence is, and this is not related to plea bargaining, this is once you get the trial and then go to be sentenced by the judge, within the sentencing guidelines, if they can depart from that, then you can find different racial bias in that as well. So there's things to think about. I hope you all enjoy your readings this week. And look at that, I only went for about 15 minutes. So that was about all that I had for this week. Please make sure that you read your the rest of your chapter for this week on plea bargaining. There's a lot of interesting information in there, as well as there's readings at the end of the chapter. And don't forget to do your discussion board and your quiz on D2L this week. And I will see you all next week, and have a good one.